Have you ever thought about who would make decisions for you if you couldn't? So, if you had a stroke or you developed dementia or had some sort of mental incapacity, most people believe that their will or their living will covers everything. But what happens if you're still alive and you can't make decisions for yourself? In this video, we're going to explore why incapacity planning is just as important as what happens after you're gone. You'll learn the key documents you need to make sure that your wishes are honored and your family is protected. We've seen firsthand how families can struggle without a clear plan in place for incapacity. There can be court proceedings, family disagreements, and a lot of unnecessary stress. But with the right documents, these issues can completely go away. They can be avoided entirely. I'm Mike Smith. I'm an estate planning attorney with Smith Barid LLC, and I'm one half of the estate planning guys. I've been practicing law since 1996, and we've helped thousands of families avoid unnecessary court intervention and ensure that their loved ones stay in control even during tough times. So what happens if you don't have incapacity documents in place? Let's take a closer look at that first. So stay with me on this for the next minute. It could save your family a lot of pain. So if you don't have the right documents in place, then your loved ones may need to petition a court to get permission to take care of your affairs for you, to manage your finances, make healthcare decisions, or even like sell your home if that becomes something that's needed. So this process, it's called guardianship or conservatorship. It can be a very expensive, time-consuming, and stressful process. Plus, the court may appoint someone that you wouldn't have chosen to make decisions for you. So I worked with a family a few years back, and there was really nothing complicated about the situation. There was no controversy. Everybody was in agreement about what should happen. We filed in the probate petition. Nobody contested that. Just because of the inefficiencies of the court involved in that particular case, it took 2 years to get someone appointed. In the interim, nobody had access to their parents' checking account to pay bills or take care of the mortgage payment or any of the other financial things that needed to be handled. And there was no one in place that can make medical decisions. So there can be huge time delays that are just a part of the process, not anything that's a particular problem or that there's been any sort of dispute or any, real issues. Just sometimes it can take a lot of time to get it done. I had another client a few years ago. When she became incapacitated, her children started a fight over who should take charge of things. And so they filed a petition. One of the children filed a petition to be appointed as the conservator and guardian, and the other one opposed that. And there was a lot of back and forth. It really was a big problem, and it took a long time to resolve that. And it was very expensive because both sides hired attorneys and spent a lot of money on attorneys' fees. There were court hearings, etc. These are all things, in my opinion, that you want to avoid if you can. So let's talk a little bit more about how we can avoid these kinds of circumstances. And oh, by the way, if you've ever seen a family go through this, then just drop a comment below or hit the like button. Let us know about your experience. That can help somebody else when they hear, what you actually went through. Now, this is where things get interesting because we can avoid any of those problems with some, fairly simple documents. And I'm going to talk to you about what those documents are. And then we can talk about another way that we can plan for incapacity that I think is the best way, that is just a rock solid way to plan for incapacity. So first, let's talk about the essential documents that everybody should have. Anybody who's over 18 should have these documents. The first one is a durable power of attorney. This document allows you to appoint someone as an agent called an attorney in fact, somebody that you trust. You don't want to name just anybody, but this person can step in and manage your financial affairs if you're unable to do so. And there are different ways that you can set up a power of attorney. You can have an immediate power of attorney where that person immediately has the power to take care of things for you, or you can have a springing power of attorney. And a springing power of attorney has language in it that says, under these certain circumstances, I want this person to be able to manage my finances for me. Now, I know a lot of people think, a springing power of attorney sounds great because it's not going to take effect unless something happens to me. So let me tell you how it works in a practical sense. A springing power of attorney typically says something along the lines of, if we have two independent doctors who render an opinion that says that this person can't manage their affairs anymore, then this person that I've named as the agent, the attorney in fact, can step in and take control of things. That sounds great. Two doctors. Well, imagine for a minute, I don't know if you've scheduled a doctor's appointment lately, but when I try to schedule a doctor's appointment, it's like months before I can get an appointment. So recently spoke with my doctor's office and they said it would be 6 months before I could get an appointment. So imagine that you're in a situation where your parent or loved one is not able to manage their affairs anymore. And now you've got to go get not one doctor's opinion, but two doctors' opinions, and you need written opinions from them. So you're going to have to set up appointments with two separate doctors in two separate practices. And your parent's probably not a patient of both of those doctors. So then you go through the whole new patient process, and that can take months to get in. So it seems like a great idea, but as a practical matter, that's very difficult. Now, you could have some individuals that you trust and know who you would agree could make those determinations about your capacity. So maybe you'd name a couple of your friends or family members that you felt confident would be able to evaluate whether you are capable of managing your own affairs or not. But it all just gets a little impractical. So I prefer an immediate power of attorney, but just know there are options there if you have some specific concerns. And my thinking on it is, like, if you don't trust someone enough to give them immediate power of attorney, then there's probably not a person that you should name as your attorney in fact. Okay, so that's power of attorney. Now let's talk about healthcare directives. This is a document that allows you, again, to name an agent to make medical decisions for you. And it generally gives you a way to make a statement about your wishes with respect to end-of-life treatment. Now, sometimes they're separate documents. You could have a living will and a durable power of attorney for healthcare. In some states, it's combined into one document called an advance directive for healthcare. Different states have slightly different variations on that. But the general concept is that you're appointing an agent to make healthcare decisions for you when you're unable to communicate. So if you can't talk to the doctor, take in the information about your medical condition, make a decision on that, and instruct the doctor what you want to do. This is a super important document. I don't know if you'll remember, but there was a family, they had a daughter and a wife, Terry Schiavo, who was in a coma and had no response to any stimulus, and there was no document. She had not made any written document stating what her wishes were with respect to end-of-life treatment. And that family spent the better part of a decade or more fighting over what should happen, whether the plug should be pulled or whether she should be kept on life support. And the case went back and forth to the Supreme Court multiple times. And eventually, I think the husband was given the right to make that decision. And at some point in time, her life support was withdrawn. But that's not the kind of situation you want your family to be in. What you want to do is name someone that you trust to make medical decisions for you, and then give them some instructions on what you want them to do. So this is names an agent. This is not a document that is instructions to your doctor. This is instructions to your agent, telling them, this is how I would make this decision if I could still communicate. So this is what I want you to do. So sometimes people think, I don't want to have an advance directive because, my family, my doctor may do something that I don't want him to do. I think that's the wrong position. I think an advance directive that clearly spells out what you want to happen will be a great help to your family and allow the person that you've selected as your agent to make a decision and to feel okay about that decision, whatever that may be. So the power of attorney, the healthcare directive, and then the third document that you need is a HIPAA release. Now, HIPAA is the Health Insurance Portability and Accountability Act, and it's a privacy law, and it restricts medical providers from sharing your information with anyone else unless you've given them specific permission to do so. That's a really good thing. But the law has some unintended consequences. Anybody that's not listed on your HIPAA release can't get access to your medical information. So if you have a child who lives in California and you live in Tennessee and you go into the hospital, they're not going to be able to get any information about your medical treatment unless they're listed on a HIPAA release. This is a federal law. So what we do for our clients is prepare a HIPAA release that spells out in advance, these are the people I want to be able to access my medical information. And that is important because then if you go into the hospital and you're unconscious, you're not able to sign a HIPAA release at the time that you go into the hospital, they'll have that document on file and they'll be able to talk to your children about what's going on with you. And then we recommend that you store these documents in a fashion that allows anybody that you need to access them to be able to access them easily. We use a company called DocuBank to do that for our clients. There are other companies that provide similar services out there. This is not a plug for DocuBank. This is not a paid endorsement in any way, but we use DocuBank. And what they do is they store a copy of these documents and they send you a card to carry in your wallet. And that card has a 1-800 number and a PIN number on the front of it. So if you go into the hospital, then the intake person at the hospital, the doctor, whoever needs to, can call DocuBank and have those documents emailed into the hospital. That way you've got access to them anytime you need them. If you'd like a free checklist to help you assess where you are with your incapacity planning, head on over to our free resources page linked in the description below, and you can download our free estate planning checklist. This is going to help you figure out where there might be holes in your plan. So here's where everything changes. Let's talk about how a living trust can make all of this easier. A living trust isn't just for transferring assets after you pass. It plays a crucial role during your lifetime if you become incapacitated. That's why it's called a living trust, because it exists while you're alive and it can function while you're alive. So here's how it works. The first thing is it gives an automatic transition of control. So when you create a living trust, you name a successor trustee who can step in immediately to manage your assets if you're unable to. Avoids any necessity for conservatorship or guardianship. You don't need to take a power of attorney down to the bank and show them that you're, in charge now. It completely avoids any of those kinds of issues. It also avoids any court involvement. With a trust, there's no need for a court-appointed guardianship to manage assets in the trust. Your trustee just takes over immediately. And then last, it's comprehensive asset management. So your trust can include instructions for how you want individual assets to be handled, how you want your finances to be handled. It can ensure that your bills are paid and your assets are protected without any delay, like we've talked about. So a living trust combined with these other incapacity documents gives you the most comprehensive plan to protect yourself and your family. So to recap, incapacity planning is more than just having a will or a trust. You need the key documents like a durable power of attorney, healthcare directive, living will, HIPAA release. Some states, you just have an advance directive for healthcare. Some states, you're going to have a living will and a durable power of attorney for healthcare. I know that's a little complicated, but by having these documents and incorporating a living trust, you can make this process even smoother and have a clear plan for who takes over and how your assets are managed if something happens to you. If you want to dive deeper into protecting your family's future, check out our next video. It's full of practical advice to help you create a complete estate plan. Thanks for watching, and don't forget to like and subscribe for more estate planning tips from the Estate Planning Guys.